Good morning, everyone. It's a pleasure to welcome you this morning to this roundtable. My name is Marie-Bénédicte Dembour. I'm Professor of Law and Anthropology at the University of Ghent and the Principal Investigator of an ERC research project on DISSECT evidence in international human rights adjudication. So today we're going to have a roundtable whose subject is the burden of proof. So very central to evidence matters. And we're going to discuss the topic with Christopher Roberts, on the one hand, who is an associate professor at the Faculty of Law of the Chinese University of Hong Kong. And he's also the author of an article which was published last year in the International Journal of Human Rights, which is entitled Reversing the Burden of Proof Before Human Rights Bodies, an article that I very much recommend to you. And we'll also have with us Hanaa Hakiki, who is a senior legal advisor at the European Center for Constitutional and Human Rights. And she deals with evidence matters as well, because actually she's part of a team who litigates pushbacks of migrants in the Mediterranean and other EU borders before international bodies. So this is, I think, going to be a very interesting discussion, because the advantage of having these two lawyers to reflect with us on the burden of proof is that they ally practice of litigating cases with academic reflection. So I think that's going to be very interesting. Maybe the first thing I could ask each of you, Hanaa and Christopher, is, in a sense, what kind of experience has alerted you to the importance of the concept of the burden of proof, and why it is really something you should not ignore in your work, and why everybody in international human rights law actually should think about it. So one of you, whomever you wishes, just tell us a little bit about the importance of the topic for you. Chris.
Okay, I was gonna give the floor to Hanaa, but since you nominate me, so thank you so much, Marie, for the introduction and for this fantastic, opportunity to speak with everyone. It goes without saying probably that I think this is an incredibly important initiative. These evidence law issues generally, burden of proof in particular, are incredibly important behind the scenes aspects that aren't incredibly visible, but play a major role, I would suggest, in determining the outcomes of human rights adjudication in different bodies. So to get them right, I think, or as close to right as possible is very important. So the experience I had that actually first got me thinking about these things was back when I was a law student at NYU, and I was part of the human rights clinic there. And they started working on a case representing an individual of Yemeni origin who was basically suspected of nefarious activities. He was picked up by US intelligence services and basically captured, taken to Afghanistan, interrogated, detained there for a while. Eventually, he was released. And along the way, he was taken through some other site, but it was never made entirely clear to him, nor was it subsequently sort of admitted where this site had been. We in the case thought that that site was Djibouti, so he was flown to Djibouti, detained there for a while. We contended before being taken to Afghanistan, and so we commenced the case against, or the clinic commenced the case against Djibouti and the African Commission on Human and People's Rights. But then the really sort of hard part of that case was making the admissibility argument, and basically, in addition to all of the other sorts of exhaustion types of questions, timeliness types of questions you have to deal with, we had this very difficult issue of, was it actually Djibouti that the claimant was sort of kept in along his way to Afghanistan? And so it became it became clear to me in the course of thinking about that. Of course, as the applicants, we brought all the evidence we could. There were some international reports on sort of these practices of extraordinary rendition that said Djibouti was one place where this, that was a part of this network, for example. But of course, it's hard as the claimants to prove, entirely clearly that it had in fact been Djibouti. And so what became clear to me in thinking about the way I thought the African Commission should consider the case was that a lot would hinge on who they thought basically had the burden of proof relative to that issue. Is it for the claimants to sort of compellingly convince the commission of this, or should something of the burden lie on the state? And especially in a case like that one, the part of the argument we tried to make was, well, look, this entire pattern and practice of violations is one which is designed to avoid accountability. It's designed to keep this information out of potential claimants' hands. It's both supposed to commit a certain sort of violation and to make accountability impossible. And so, for that reason, sort of the argument we wanted to make there is the commission should consider the burden on the state to, sort of disprove that it was in fact Djibouti after the claimant had made at least a prima facie case. But also, so starting from that, several years later, I helped to coordinate an amicus brief that I don't think is publicly available, but for that same case, sort of going deeper into the issues, and that was actually the inspiration for this article. But it basically, that was the starting point that got me thinking, okay, actually, these issues are kind of somewhere in the background, but incredibly important in terms of outcomes.
Okay, thank you very much. So in brief, in a sense, if a claimant has a claim, we expect them to bring the evidence of their claim. But for someone like the man you're talking about, the evidence was not in your hands because there was no evidence. The his whole treatment would have been denied by states. So we can see that in this case, it's really important that the adjudicative body does not just leave it to the applicant to have to bring the proof. Otherwise, a violation of human rights is never going to be found. Okay, so thank you for that, Chris. Hanaa, could you maybe tell us a little bit about what brought you to think about the burden of proof?
Yes, thank you. Yeah, and thank you, Chris, for that answer. It's really interesting. And it got me thinking that I actually didn't really have the word burden of proof or the idea of the shift until the first judgment of the European Court of Human Rights in our case. And I think that, and I will get into that later, but I think it's because I come from a sort of, I was, trained as a national lawyer in the UK in litigation against the state, in particular the police, prison authorities, and immigration detention. And the UK, and these were civil sort of proceedings because nobody believed in criminal investigations, so they were skipped from the start. out of political reasons and sort of acknowledgement of their bias, of the bias of criminal investigations when it comes to investigating the state itself. And there, I think it's it's a very controlled environment in a way, because in the UK, they've developed all of these rules that authorities, need to keep very detailed record of the people that they have in their custody. And also you have CCTV everywhere, inside and outside. So you'll constantly have records of what's happening to the person at almost every corner of a prison or of a police station. And you also have a duty of disclosure, so that, not only inferences can be made out of a failure to disclose information, but also it lays on the lawyers themselves to not act in bad faith, and they can actually put their practicing certificate at risk if they don't disclose things to the court because their clients told them not to. So as a lawyer, really careful, because your first duty is to the court. So when I started working on summary expulsions at EU land borders, for me, it was the same sort of situation. You had people that were sort of under the control or in the custody of state agents, but the main difference was that there was like a void in terms of records and cameras, and there was a state that had that basically was acting in bad faith. But also we didn't have this duty of disclosure in the same way. We didn't have the same ethical rules framing the proceedings, and we had very little chance to argue evidence. So unlike in the UK system, where you have a whole pre-litigation phase and exchanging correspondence, and it continues, and you can do as many rounds as you think are necessary on specific points in front of the European Court of Human Rights or UN treaty bodies. You have a very limited, in front of Strasbourg, you have 2 rounds of submissions. It can be more in front of UN treaty bodies, but also the first one, you're limited to 20 and so pages. So you actually have very little space to get into the detail of what evidence could exist and who should bring it out. And that was, of course, something that I always had an intuition, not an intuition for, but a thought for. But I now think that framing it in terms of burden of proof and when it should shift from the very beginning in this sort of theoretical framework would make it, would push the court to be more consistent from the start, and would give applicants a better chance to have the factual basis of their case better considered by the court.
Thank you very much, Hanaa. So very, very rich answers from both of you. And there are 2 thoughts which come to my mind. One is that there are so different ways of proceeding in different fora, and that will have implications. So you were talking about the UK and the European Court of Human Rights having very different ways of dealing with evidence, or making it possible even for evidence to come through. And so, and Chris, in a sense, you didn't tell us what happened to your case. So maybe I'd like to start with that, and maybe Chris also asking you to reflect about how different it may be to adjudicate a case in an international human rights forum, and whether, as you've done this article, which is comprehensive, whether different international human rights bodies do it differently. Because, Hanaa was telling us what would be really useful is that right from the start, in a sense, the adjudicatory body accepts that there will be a point where the burden of proof will need to be shifted in this particular situation, so that everybody would be clear right from the start that the burden is shared. So if you could reflect a little bit about that, Chris, that might be very useful.
Yeah, sure. So I'll take the comparative question first, and then sort of say a few words about that case that I mentioned. So comparatively, I mean, I guess one of the first points to note is simply that sort of across the bodies in question, I think it's it's something that the language exists from previous cases, that language is replicated as it so often is, it's there within the judgments. There seems to be more, in the more sort of the areas where there's kind of clearer precedent, like for example, forced disappearance or, state detentions of people. There's a little bit of a clearer approach. But generally speaking, I think all of the international rights bodies are a little bit less than entirely clear in terms of what they're doing on these issues. And I think that, that has sort of probably multiple sort of factors underlying it. I think actually, look, also teaching evidence on a national level in Hong Kong, it's just, I mean, my sense is that all courts are a little bit, evidence is difficult and it happens as things are going along. Courts are always a little bit less clear about it than they could be. So that's part of it. I think, of course, there's a natural tendency for adjudicatory bodies to want to maintain their own discretion in different spaces. So to a certain extent, perhaps they don't want to fix things too clearly, and they can sort of, and also, of course, presenting the evidential standard they're using in different ways can in and of itself get them to different sorts of outcomes, and that can potentially be useful for a court if it wants to get to one sort of outcome. It's a little bit less confrontational maybe to do it by talking about the standard applied than something else. But that's exactly, that's also exactly why I think it's important to have more clarity on those issues. But so going on comparatively, I think all bodies are, somewhat, that they're flexible. Things look different from case to case. But I mean, just generally speaking, in this context, as others, I tend to see the European system as sort of perhaps an outlier, whereas I think the inter-American, African systems and the UN treaty bodies tend to be more similar to one another. And we could go perhaps later, into why that is, but basically all of those systems seem to have a little bit more of an equitable mindset. They seem to, be more willing to reverse the burden. Basically, you can, I think, from the paper, for example, you can see statements from the European court on the one hand, from the African system on the other, that seem to be very diverging in terms of, the European court tending to maintain a strong balance in terms of placing the burden on the applicants, whereas the other bodies are more willing, explicitly or implicitly, to reverse it. In terms of so that's sort of the comparative question. In terms of the case, I mentioned, unfortunately, to the best of my knowledge, like some other cases I was involved in at the African Commission, and like many other cases, there's been, over the last 8 or so years, the Commission has kind of shifted away from its case sort of fully fulfilling its case consideration mandate, and has started to, devote more attention to other types of activities, issuing guidelines, for example. So I believe that case is still pending a final decision, which is also the case of many different cases. Sort of admissibility has been argued, or perhaps admissibility has been accepted. Oftentimes the state simply hasn't responded at a particular point within the case consideration, even though there are guidelines on the time they have to do that. The Commission has just kind of let the cases linger indefinitely without moving them forwards.
Thank you. So if I go more directly than what you have been, but I think we mean the same thing, the European Court of Human Rights is reluctant to shift the burden of proof, though it has done it. We know it has done it in a number of situations, in a sense, following the lead from other bodies, including the Inter-American Court, which is well known for, in practice, if not in explicitly, but in practice, having shifted the burden of proof right from its very first case, which was a case of forced disappearance. And of course, it was a forced disappearance. The family of the disappeared had no way of bringing evidence. And so the Inter-American Court accepted to make inferences from all the circumstantial evidence which existed. I think it will be important at some stage in this discussion to kind of think of what difference it makes to talk about inferences, which is what the Inter-American Court did in its first case, or to actually name that there is a shift in the burden of proof. In practice, in a particular case, I don't know that it makes a real difference. But I don't know if either Anna or Chris, you would like to reflect about what difference it would make for you especially when you litigate a case, whether the shift has been explicitly mentioned or whether it remains unsaid, even if in practice it is actually implemented. Hanaa, would you have any comments on that or not really?
Yes, I think, and maybe I can answer by illustrating how it all came about. So in the litigation that we support here at the European Court, European Centre for Constitutional and Human Rights in front of the European Court. So it's about summary expulsions at the border in situations where people won't be identified, so there'll be no paperwork. In situations where states are implementing covered policies that are not acknowledged as such just yet, and where, as you put it, Chris, these practices are designed to avoid accountability. So typically, journalists will be kept at bay, any third parties will be kept at bay, to not have any witnesses, to not have any images. The mobile phones of people who are summary expelled will be seized and destroyed. So there's really practices at different land borders with different practices, but you see that one thing is for sure, states are doing what they can in order, and not only states, also Frontex is another agency. They're doing what they can to sort of really keep it all in the dark and make sure that neither the victims, nor the NGOs, nor the activists, nor anyone has access to any evidence about the occurrence of these summary expulsions and the involvement of the different actors in them. And so that's on the one hand, the factual, what happened factually. In court, so the first case that we litigated had to do with the land summary expulsions by Spain to Morocco. And Spain's position was outrageously sort of, you need to prove everything. You even need to prove where the border is. So, we were saying, there's a border fence, they're behind a border fence. Obviously, they were in Spain, so they were under your jurisdiction. And Spain would say that may or may not be true. It's for you to prove where the border fence was, which to an extent that it became sort of ridiculous, you need to prove that Spain exists as a country, it's on you. So it really made you think, okay, how far do you take this thing? And so we started, digging into, it was clear that we wouldn't have papers because Spain wouldn't issue them. And it was also clear that we didn't have images because the journalists couldn't get close enough to have images of the applicants where they would be recognizable on behind that border fence. And we also had, evidence of the fact that it was the Spanish authorities that had stopped the journalists getting close to get those pictures. So, I would say, thankfully, in relation to litigation in Strasbourg, there are practitioner textbooks, and this is something that is really lacking for UN treaty bodies. because oftentimes commentaries focus on the material violations themselves in the articles, but not on the practical side of things that is so important, like how the committees deal with evidence. But thankfully, for Strasbourg, there is one by Leach, who comes also from an Anglo-Saxon sort of point of view. And I think this is why it is a practitioner's textbook to Strasbourg. And so there's a chapter about evidence there. And we started putting together an argument as to, you know, when the state has control of the evidence, or when the state has taken steps to, you know, when it's the state's fault, basically, that the evidence doesn't exist, the inferences should be made. And also drawing on the duty of the states to cooperate with the court under Rule 44. And so that was I mean, and for us, it's just, you know, what mattered was what the court would find we had to establish. And we wanted the court to find that it was enough for us to establish a systematic practice of summary pushbacks, and the fact that the applicants were there at that border at that time, that they had a credible statement. And then in the judgment, in the Chamber's judgment, the court applied essentially a jurisprudence that they have since the mid-90s that started with deaths in custody, and that it gradually expanded to deaths in zones within the exclusive control of the state, as well as enforced disappearances, saying that basically when the situation is under the control of the state, if the state doesn't come up with a satisfactory and convincing explanation, strong presumptions are made. So that would be the jurisprudence. But here, in our case, the Chamber found that in situations where there was no evidence of an expulsion because of a state practice, so because of the state, there would be a shift of the burden of proof, and that applicants in those situations of summary expulsions, so when you could prove that there was a practice of summary expulsions, essentially, as an applicant, you only need to bring a prima facie case. And I think at this when we're talking about this very beginning of the facts that you need to establish, just, you know, the applicant's victim status, that they were there and that this happened to them. I think there is very useful to already talk about a shift of burden of proof, because then anyone bringing a case will know, okay, this is how much I need to bring the case. Yeah, so I think that would be my answer, that in that particular case, I see how it's useful to have it, because it's really just the beginning of the case. And so drawing inferences would not be as strong and as clear for future applicants, I guess.
Okay, so you say saying that it's shifted could be useful for the applicant. What struck me in what you were saying, you were really saying, well, in that case, Spain was asking us to prove everything. And it seems to me that that attitude is, if not encouraged, in a sense, made possible nonetheless by the fact that the European Court of Human Rights has always said that it was applying the standard of proof of beyond reasonable doubt, which of course is an expression which comes from the common law in criminal law. And here we are not dealing with criminal law, we're dealing with international human rights law. And it's been accepted. The court itself says, oh, you know, this is not a criminal standard, but nonetheless, the very language kind of could be misinterpreted to suggest that you need to prove everything, because that's what it means in its original setting. So it strikes me that this idea of the burden of proof is something which cannot be divorced also from the principles and the practice which are applied in terms of the standard of proof. Because of course, you know, if you, and you also mentioned prima facie as opposed to, in a sense, the real thing. I mean, prima facie in itself suggests that you don't need to reach such a high standards, because at first sight would be enough. So all these questions really come to be related. Christopher, is there anything you want to add on these questions?
Yeah, sure. Thanks. So I mean, fantastic comments from Hanaa and yourself. So I think, I mean, picking up on the beyond the reasonable doubt, right? I mean, so sort of the way I prepared my paper on this is sort of perhaps an unusual methodology that is, you know, one I guess comparativist academics alone can use, which is to be a little bit relaxed about how exactly each system thinks, to look across them and to try to find common sort of principles in emerging at different moments from the jurisprudence. And one thing that was really interesting is mostly, you know, you can kind of see the same inclinations and ideas. One thing that really stands out is the European Court using that language, which is so clearly contrary to, you know, the even many more statements from the various bodies that this isn't a criminal trial light. It's almost certainly contrary to what they actually do. It's clearly not right in the human rights context that, you know, that there are reasons why when all of the might, right, the criminal trial is one where all of the might of the state is brought to bear against an individual. And so it's in recognition of that massive disparity of power that, you know, the burden of proof is shifted. It's to try to make sure, okay, you know, they're already in a very difficult position, so at least we have to give them this. Well, in a human rights context, right, it's exactly the other way around. Now the state is the one that's sort of the defendant, but they're still the one with sort of massively more access to resources, the ability potentially, and this is a very real thing, to intimidate or retaliate against the people who are bringing claims, for example. And so the idea that you would sort of protect them with that standard is sort of as a matter of principle, I think, really troubling. Of course, I can understand why they use that language, which is simply sort of the long, slow process of evolution of international human rights institutions required state buy-in. States, of course, will be reluctant, perhaps, to submit themselves to this type of supranational adjudication. So they want various guarantees. And that was one way of kind of saying, okay, we'll give you a strong guarantee, but still sort of, I would say the ongoing use of that language is a problem. And then just on your first question, in terms of inferences versus sort of reversing the burden of proof, I think I agree entirely with the points Hanaa was making, I think, in terms of, right, and inferences are great if you have a good judges or commissioners and they're willing to think sort of seriously and reasonably about the situation and who has access to what information and so on. But inferences aren't, right? They're always something sort of discretionary that a particular tribunal may or may not decide to do. Whereas when you start talking about reversing the burden of proof, it can be something that is laid out clearly in advance. It can be something applicants can potentially point to and say, look, no, you know, when the state keeps saying, please, you know, you have to prove everything, say, no, look, actually, you're the one who has to come in here and submit compelling evidence, and you have to do that, for example, because you've been, you know, denying other possibilities of this evidence being produced.
Thanks, Chris and Anna. One of the things you said, Chris, at some stage, you said, well, obviously, in the criminal system, the standard of proof beyond reasonable doubt, which exists in the common law, is there to protect the individual, not the state. In this case, if you apply it in international human rights law, if you apply that standard, it will be to the advantage of the defendant state. It won't be to the advantage of the person who is actually alleging that they have suffered a human rights violation. And I mean, I think that is an absolutely crucial point, especially when you consider, and I would expect that for both of you, this has happened, that the claimant, the person who says that they've been victim of a human rights violation, may feel extremely vulnerable when they have to produce evidence. So I don't know if this is something that maybe you could pick on as well, how it is particularly difficult in some situations where the allegations of human rights are serious, where it's not, I mean, just something where the facts are not in dispute and where you decide on the interpretation and how far you would go, but that in a sense, requiring the applicant to bring a case in itself can be putting them in a dangerous situation. Does that ring a bell?
Yes, I agree. And I do think that the court doesn't take that into account enough. So I think there's a lot to be said, as Chris said, as Marie, you also sort of underline that the whole standard of proof and the way that that Strasbourg deals with evidence just reflects its state bias, basically, and even more so, I would say, when it comes to migration cases or any cases that are highly politicized. I think pushback litigation at the moment is really interesting to look at for that, because how the court is dealing with minimal rights at our borders in the case of summary expulsions, and in a political context where it really hasn't been encouraged to be scrutinizing, to say the least, shows the power of how the court assesses evidence as its kind of black box. So on the one hand, the court will treat each case as an individual case, and whatever factual findings are made, I think for anyone reading the judgments, the conclusion is, well, in that particular case, they couldn't prove this or that. But actually, no one has access to what was in the case file, because the submissions, even though they're public, are only accessible if you actually go to the court and request access to the case file. And on the other hand, despite that very peculiarism, the case made about this individual case, and also the way that the lawyers dealt with it. So there's another sort of blaming paradigm there, not only from the applicant who's supposed to do all the work, despite the trauma, despite the risk, despite none of that is taken into account by the court, right? But also, the lawyers should be doing a good job, and who knows whether they have. So you have this over peculiarism of the case versus the actual general conclusions that are drawn from judgments. So even though it is that specific case, then we will say, Strasbourg has ruled that, for example, living conditions in Greek hotspots are fine, or I don't know, asylum was accessible in Serbia. Also, these very general conclusions. And I think, the court doesn't, the way that the court deals with cases doesn't reflect on neither the efforts and the exceptional character of the cases that it has in front of it, because of the many hurdles to access to justice, on the one hand, and on the second hand, the weight of its judgments, not only in its own jurisprudence, but in national jurisprudence across the Council of Europe and potentially beyond. And I think the court's been extremely unrigorous in looking at facts when it comes to summary expulsions in particular, and the application of the prohibition of collective expulsions in particular, where now, even though we've managed to establish that the burden of proof is reversed as to whether or not there were a summary expulsion, the whole question as to whether there was a violation lays with the question of whether there were access to legal entries at the particular border. And there, I think it's one of the situations where your article, Chris, is very helpful to argue that there should be a shift of the burden of proof, because actually only the state has the necessary information to know whether or not it gives access to anything. They will have all the data, they will have all the statistics. And yet the court puts it entirely in the hands of the applicant, and even when the applicant actually proves that there was no access, has such a state bias that mere claim by the state, which is not backed by any supportive evidence, will be taken at face value by the court. Yes, and I think just if I could do a call to academia, it would be to go and look into the files, and you will see that where applicants have hundreds of annexes, the state will barely have 20. For each submission, they will maybe submit 3 or 4 documents that will generally be provisions of the law that are available on internet, maybe a few standard forums, and that will be it. And I think that in itself speaks for itself completely.
Okay, I will add 1 or 2 things on what you have said, Anna, because I have read your post on the Strasbourg Observer's blog, which everyone in this audience know about the blog, but it's about the ND and DT case. And in that blog post, you explain how you had really brought a lot of evidence, which made it crystal clear that there was no access to legal procedures of asylum for migrants. Maybe you can say a little bit more about what this evidence were, but there was freedom of information, there was declaration from the government in the press, there were statistics from the government itself as the source saying that well, there had been no one who had claimed asylum at the border. So you brought a lot of documents. You will correct me at the end of my talk to say, oh, actually you didn't get this right, or but the gist is that you had a number of documents, and these were not just hearsay or whatever, they were proper documents. And then the Spanish government lawyer appeared at the hearing of the Strasbourg court and said to the court, oh, in this year, or I don't know exactly when, actually 6 migrants did claim asylum at the border. And there was no backup evidence of that. It was just an oral statement. And in its judgment, the court followed the Spanish lawyer rather than your documents. And to me, when I read that, I found it absolutely shocking. I mean, obviously, there is a reason why I've decided to put a research project such as DISSECT together. Obviously, I kind of came to the realization that the way human rights bodies deal with facts is amazingly important. That's going to have an enormous impact. So I expected to, I suppose that in my book, When Humans Become Migrants, every so often I say, I can see that the migrant applicant was being asked by the court to submit some kind of evidence. It might have been implicit, but that I felt, but the applicant would never have been able to do this. So that's probably what inspired me to put DISSECT together. But when I read your blog on the ND and DT case, I thought this is going beyond what I expected. It's more shocking than what I expected, because the court dismisses evidence which has been presented in writing, but probably, I suppose, also during the oral hearing, thus as if that evidence does not exist. has never been submitted by the applicant and follows an oral statement backed by nothing by the state. Am I understanding this right?
Yes, absolutely. And I think an added difficulty with the ND and NT versus Spain case, which is a case that was initially unanimously won at chamber, where we had this burden of proof shift found, and then unanimously rejected at grand chamber level, where the grand chamber still reconfirmed this burden of proof shift to establish the summary expulsion, but then came up with a new test for the prohibition of collective expulsions. I think an added issue was that at the time of the grand chamber hearing, we had no idea how crucial this question of legal entry would actually become, because the test came only at judgment point. So we were being asked all of these questions that seemed utterly irrelevant to the jurisprudence about collective expulsions up until that day, about access to asylum in Mauritania, access to asylum in Western Sahara. I mean, really, we spent so much time doing so much research about things that had nothing to do with the obligation of Spain to identify individuals before it expels them. Just because, you know, we take it upon ourselves to do a thorough job, and we always said in submissions that it is completely irrelevant, but for the sake of completeness, here are our answers to the Spanish state, which will come up with all sorts of nonsense. I mean, really, all sorts of nonsense about the numbers of, I don't know, agricultural workers in southern Spain and how many of them have visa issues, things that, I mean, anything, anything. So it's a, you know, and then the court decides that this is relevant. Okay, but the evidence still is that at the time, so the court says, if these guys could have gone to the border crossing point and requested asylum there, basically it's their fault that they were collectively expelled because they chose to enter irregularly, using a mass of people and attacking our borders when they could have gone through the border checkpoint. I think already in that argument, one can see the state bias, because I think it's extremely, in a way, violent, at least very disrespectful from the court to even think that people would risk their lives and their physical integrity if they actually had a choice. So I think that's the first point to be made, that like it goes against common sense. And it also, of course, completely overlooks the reality of border checkpoints where you need to exit a country before you can enter one. So it's quite clear that undocumented migrants can't actually do that. I mean, this is just absolute common sense. If you dig a little bit, you find out about it. Court didn't want to take it. The UNHCR, so we had the factual basis was there had been a parliamentary question about exactly that point, you know, how many sub-Saharians ever managed to claim asylum at the border checkpoint during these dates? 0. There was actually no possibility. So at some point, 3 months after the summary expulsion of the applicants, Spain had put in place asylum office, so beyond the checkpoints, because at that point Syrians were starting to arrive. There were many reports explaining that the reason why Syrians could actually get through the many border checkpoints before getting to the asylum office was that physically they looked like Moroccans, so they could get through. So there was a racial profiling, you know, as always as borders, there is a racial profiling issue in terms of access. And then Spain sort of at some point did disclose a number of statistics that were super unclear in Excel sheets that we had to really focus to understand. But what came out of it is that the first sub-Saharan person that could claim asylum at that border post was in 2016. So the case is from 2014, that there were 2 people, and journalistic investigation found out that these 2 people were 2 women that basically had worn a burqa in order to cover the fact that they were Black. And that's how they could get through. And, you know, you've got UNHCR at the chamber, at the Grand Chamber hearing, making it part of its speech to say clearly racial profiling happens at that border, and clearly sub-Saharan refugees have no access to that possibility. Only Syrians can get through. And this is quite complicated. We've actually done a video with forensic architecture, kind of explaining what evidence was there, what the border looks like, and how the court dealt with it. So if you want to get more into it, you can go and look at that. Precisely because, as I said, you know, the establishment of fact is very nitty-gritty, and aside from the two lawyers in the case, I don't know who engages with understanding what is in the case file and what does it actually show. The court found that it was just not convinced with UNHCR's argument, and that given that the Spanish lawyer had said that 6 people had access at some point in 2014, that seemed to look like the applicants could have had access. The 6 people that the Spanish lawyer was talking about, at some point there was a number 6, were people that had claimed asylum at police stations. So they had gotten through boats, not land border. They had been apprehended at the coast, taken to the police station and claimed asylum there. And on that basis, the Spanish lawyer had argued, sub-Saharan migrants and asylum seekers have access to this procedure that didn't exist at the time, actually, to claim asylum at the border checkpoint. And the court was happy to accept that. And I think another case where it did an even worse job, and it's kind of even more shocking, is a chamber decision in AA and others versus North Macedonia, where the case was actually about the closure of the borders. And there, because we knew that legal entry would be a thing, with it all of the, you know, freedom of access information, things that we could, and we had very clear data that nobody had ever been able to claim or obtain a humanitarian visa at any border checkpoint of the country between 2010 and 2020. Our summary expulsion was in 2016. And the court still found that it was accessible because before the closure of the border, it was possible to register an intention to claim asylum, but after having crossed irregularly, given that people cannot go through border posts. And for some reason, the court decided to jump to the conclusion that this had happened at the border post, but it hadn't. It had happened at the reception center.
I mean, what that shows to me, it's obviously, as you say, it's nitty-gritty. It's very difficult to get to the bottom of it. And at the same time, you have to do it as lawyers. And I mean, you know, when you talk, the conclusions that the court draws from the variety of submissions that it receives seems to me completely, it doesn't make sense. And I find that quite horrifying. But I'd like to move on. And Chris, at some stage, I mean, it's very clear that in the European court system, it's very individual cases. So we talk about a particular individual who has had a problem. And then maybe there might be general conclusions out of it, but nonetheless, you need to have one applicant. How is that potentially different in the African system?
Yeah, sure. Great question. So the first thing I think is, okay, so the first answer many people would often give to sort of how is the African system different from the European in terms of sort of an individual vision of human rights and human rights adjudication versus a more collective one, is to simply note, okay, the African Charter isn't just human rights, it's also people's rights. Clearly, from the very foundation, there was a very different substantive understanding of who exactly human rights are for, how we should, or people's rights are for, who exactly rights are for, how we should think about these things. There's a, you know, you can sort of very clearly see different foundational concepts operating, and that's definitely, I think, part of the picture. But another thing that I think is part of the picture and perhaps less recognized is that within the African system, but also the inter-American system and sort of historically within the European system, although in a slightly different way, and obviously it's gone away from it, there are also commissions that decide cases that sit sort of normally, or in the inter-American system still sort of, you have to go there first. In the African system, sometimes it's possible now to go directly to the court. But the existence of that commission does a number of things, right? I mean, first of all, commissions are great because they're not just adjudicating cases, they're engaging in a lot of other types of human rights activity that I think are all very valuable in their own right. Secondly, I would argue just having multiple fora you can go to bring a claim is useful in and of itself. Sometimes one ends up having a lot of backlash against it. Okay, maybe that one is sidelined for a period of time, but there are other forums that one can access, and that is, allows for good work to go forwards. But above and beyond that, when a commission is also deciding cases within a system, it's, I think, interesting and still underthought about that it does so in very different ways, right? Partly it's because it's not a court, it's a more flexible body, so it can adopt a much more flexible approach, for example, to the fact that many, many different people can bring claims together. You can have group claims that both the inter-American and African systems have been pretty happy to consider. Sometimes those commissions even join themselves claims from different applicants or different groups of applicants because they see them as going to a similar situation, even though maybe they come at it from different perspectives, involve different individuals. They don't have binding powers of judgment, which also gives them they can be a little bit more flexible and creative in what they say. They can branch out a little more freely, but also because they are not only deciding cases, but also, for example, having regular sessions where they hear from human rights organizations in the region they're representing about the different problems in different countries. They prepare thematic reports, they prepare country reports, they prepare reports on really serious situations of violation. So they themselves are putting out material saying, there is a sort of systemic situation of violation here, and here are the aspects of that. That means both they know it and you have a particularly authoritative source to rely upon within that system to make those claims, right? So then when they go on to decide a case, they'll have all that in mind. They'll even have their own materials that can be relied upon to sort of substantiate, for example, is there a systemic situation involved here? And then, of course, especially if they're referring a case to a court, and of course, in Velázquez Rodriguez, for example, that was sort of actually the way the procedure worked. It was the commission arguing in front of the court, having already decided sort of along many of those more progressive lines. So, part of why Velázquez Rodriguez, part of why the Inter-American Court kicked off so sort of assertively is because it was continuing that momentum and imparted by the commission, I would argue. And it's much harder for a court to, right? If there's a commission saying these things very clearly, that means the court presumably has to already, it can't pull things back so far, or at least it looks even more clearly, it's even more apparent that it's just making a political decision if it decides to do so. So I hope that I sort of...
Yeah. So basically what I take from that is that the existence of a commission and the way the commission works also at looking at situations, because it's part of its job to look at situations rather than just individual cases as they write reports and as they collect information on countries, and is that it cannot not influence the way they will also then approach an individual case which fits the situation that they're aware of through another part of their mandate. And so ultimately this is also going to have an influence on the way that they approach evidence. Okay, I think we should soon close the my questions to you, although it will be followed by questions from the audience. So my last question to each of you would be, do you have a takeaway for the audience? Is there a point that you would like to leave us with? Maybe you have none, or no, Hanaa, you start.
I mean, I would really advise, or I don't know, hope that, and you're doing it through this project, of course, but I think it's a broader call to go and get the files, because, and look at what the submission said and how did the court deal with them. Because I think the establishment of facts, or at least from what I can see in the jurisprudence of the prohibition of collective expulsions, which can be taken sort of just as an example, is that this is where, you know, the court puts the dirt under the carpet. So when it's sort of, it allows it to pretend to still have some sort of coherency in its legal principles, and that's the exit point it has, to just do a false, erroneous assessment of the facts that nobody will dispute. Because also from the, I mean, we do that because we support the litigation. We're not doing the litigation, so we actually have the space to then go and do videos about, you know, what was the evidence and how did the court assess it. But organizations or lawyers that do the litigations themselves will never do that, A, because they have cases pending, and B, because it seems so petty to come and cry because your case was dismissed. When actually, I think, you know, the court should be held accountable for what it's doing, because it has immense power. And especially, I mean, if I hear about the commission, we don't have a commission anymore in the Council of Europe. We have the Committee for the Prevention of Torture and the Commissioner for Human Rights, but the court is completely not taking their work into account. And it should be held accountable for that too. It's there's a complete dissonance between what the CPT and the Commissioner are doing on the one hand and how the court is dealing with these issues on the other hand. And again, if one looks at rights at borders, this is quite clear. Yeah, so that would be my call. Please go to Strasbourg, get the files.
Okay, so very important work also for academics, nitty-gritty, but not conceptual, but at the same time at the heart of what human rights litigation is about. What are the facts? What has been submitted to the court? What does the court accept and what does it ignore? So, Chris, any final point from you as well, or?
Yeah, so I mean, I think, as I said at the very beginning, and sort of the implicit premise of this meeting, right? I think these evidential issues around the burden of proof are incredibly important. I think there are actually several procedural issues, including evidence that are sort of the invisible and sort of systemic design, that are the invisible architecture of the human rights systems. They determine what, you know, what is and isn't possible, as Hanaa was saying, right? There's sort of, as academics, it's often hard to access, you know, you see the final judgments, but that in itself is such a tiny piece of what's happened and gives you, as a piece of evidence about what's going on in the human rights process, it's a very small piece of the overall picture. So you need to look much further, but then further, there's the question of what cases never get brought or never get accepted as admissible because people know in advance the rules as they're set up, and sort of how courts approach the burden of proof, for example, is one area where you know, where a change in the rules can actually, I would argue, have a really large impact on the types of outcomes that are produced, and so it's incredibly important. And just as a small sort of attachment to that, I'll say sort of when I wrote the article, Marie, you've said some nice things about it, but I regard it as deeply imperfect. I think the most most I could have hoped was that sort of people would pick up this type of issue and quickly render my stuff outdated and limited. And I think that's exactly, what I see happening already with this project and with everyone who's part of the team. So, I think that's incredibly important work and look forward to, following all of the outputs closely.
Okay, thank you very much, both of you.